Welcome to the Libertarian Counterpoint. I'm Richard Fields. On the program today, we have Caleb Trotter, a member of the College of Public Interest Law, a fellow at the Pacific Legal Foundation, and Manuel Martin, who ran for Congress as a Republican candidate, Assembly as a Republican candidate, California Assembly District 9, a couple of years ago. So welcome to the show, gentlemen. Let's talk a little bit about something that's going on in Southern California. It's the County of Orange, deep in Republican territory, I've heard, but I'm not so sure after hearing about this case. It's in the city of Anaheim. It's the California parent trigger law being violated by a school district in Anaheim. Tell us, first of all, what's the California parent trigger law?
Well, back in 2010, California became the first state to pass such a law, and it's in response to what shouldn't come as a big surprise. School districts and teachers unions are very much opposed to the growing charter school movement and basically do everything they can to prevent charter schools from expanding and becoming more prevalent. And so with students and families who were trapped in perpetually failing schools, the legislature realized that they needed to create another mechanism. So with the parent trigger law, if the parent's kid's school is meeting certain metrics for poor performance, then if at least half of the parents all come together, agree that they want to petition for a specific change in the school, then they do that and the school has to do it.
Okay. So what happened in Anaheim?
Well, there's this little elementary school called Palm Lane in Anaheim that met this criteria.
And by meeting the criteria, it was meeting negative criteria.
Exactly. It was by all means a failing school.
Okay.
And the parents weren't able to do anything through traditional means, like in
the PTA meetings weren't helping.
The
parent-teacher councils weren't helping.
Principals were basically in and out the door, and so they banded together. They had about however many parents signed is a matter of contention at the moment because there's an ongoing lawsuit, but they put together a petition, wanted to convert the school into a charter. The school district came back and said, well, you didn't really do the petition correct. And they said, well, okay, what did we mess up? What do we need to fix? And so they gave them a deadline to do this. And the very next day, the school district sued the lead parents to basically say that the school was not subject to the law.
Wait a minute, the school sued parents?
Exactly. It's rather unusual.
Okay, based on what?
The federal government gave the California State Department of Education a waiver on reporting one of the academic accountability measures for the school for the year 2013 to 2014 because the state was changing the standardized testing.
Okay.
And so while the changing was in place, the mechanism wouldn't really work that well, and so the state got a waiver. This is part of No Child Left Behind. And so they had that waiver, and so the school district came in and said, well, since this criteria we were technically waived from, that means this law doesn't even apply for this year. And it's a rather strained reading of the statute, and it's very evident that they just kind of came up with this at the very last minute to avoid this.
So if they would not have sued, the majority of the parents would have been able to go ahead and start their charter school. Is that the way that would have worked?
Well, they still would have been debating over whether the petition was done correctly or not, and the evidence that's available shows that the parents pretty well followed the law and did everything they needed to. But if it came down to it, that could have been its own lawsuit over whether the petition was done correctly or not, but that would have been a rather simple matter of whether did they cross their I's and dot their I's and cross their T's. But instead, the school district just made this rather unprecedented move and just sued to get the court to say whether it applies to them or not. And so in the district court just resoundingly rejected every argument the school district made and said, no, absolutely, this law applies to you, and the parents did everything right. So now the case is before the California Court of Appeals.
In Southern California.
Exactly.
And what's the Pacific Legal Foundation role in that case?
We're filing an amicus brief next week supporting the parents, basically showing that this law does apply to the school. we found various measures in the State Department of Education's own documents showing that, based on their own practices, their own interpretations in tandem with the United States Department of Education, that a one-time, one-year waiver of one single aspect of a multifaceted law can't just effectively repeal this law for all the schools in the state.
So in other words, there's randomly picking a number, a dozen different criteria that the schools are being subjected to that would be a trigger point for allowing the parents to go ahead and try to change the school to a charter school. The school is arguing that since one of those trigger points had been waived, the heck with it, just throw out the baby with the bathwash?
Essentially, and what's most outrageous is the one thing that was waived is only applicable to federal law. It has really nothing to do with the state law.
And the parent trigger law is a state law?
Exactly.
Okay. So they obviously have no leg to stand on. What's your prognosis for the way that the rather liberal California appellate system and Supreme Court system in California will deal with it?
Well, based on how emphatic the trial court's opinion was, and just basically tossing aside all the school district's arguments and the additional evidence we've found that the own State Department of Education is interpreting, I think the parents have a very strong case, and it looks good.
Okay, good. Is this something that will gather momentum? If they're successful in Anaheim, will it gain momentum? Is this a movement that will gain momentum, and we'll see more and more schools move in a charter direction if they don't start improving?
It's hard to say with the parent trigger law. Since California passed it, about 7 other states have passed similar laws, but it's only been used so far in California, and even with that, it's only been used a few times. So there's not really strong evidence on how effective it really is, but it does serve as another option for parents who have kids in schools that are just continually failing and they have no other options. So it's a valuable option to have out there, and frankly, it should remain.
At the very least, it keeps the local school boards and school principals a little bit more honest than they would be otherwise.
Absolutely.
Okay. Docs versus Glocks. Tell me, that's the slang term for the case. That's not what it's actually called. It's a First Amendment versus the Second Amendment case. Is that right, or more or less?
Well, that's how it's portrayed, and that's how it was portrayed when it was passed. So the case involves a Florida statute. A number of years back, there was apparently a story where a young mother had gone to see a pediatrician for her young child. The child was an infant, and as a part of asking questions on general household safety, like are poisons locked up, are there any weapons in the home, things of that nature, just to generally try to ensure a safe house. Well, the mother was very offended by the fact that the doctor asked if there were any weapons in the home. She refused to answer, and apparently this doctor felt that the woman's lack of trust in the doctor was going to be a problem for their relationship going forward, and said that she should find another doctor. Seems kind of a strange story, but this led to Florida passing a law banning all doctors from asking their patients any questions about their gun ownership or possession unless it was a situation where the patient was in a mental health crisis and the doctor was truly concerned that maybe they would harm themselves or someone else. But basically the law just effectively says, doctors, you can't even bring up this topic whatsoever. And so it's truly a First Amendment case. It happens to center around a Second Amendment subject matter, but this was a Republican-passed bill. A Republican governor signed the bill, and the NRA, a number of other pro-gun rights organizations have taken up in support of this law. So a group of doctors sued, saying that this violated their First Amendment rights. They won in the federal district court. Then it went to the 11th Circuit based out of Atlanta, and it became a circus there. The first go, the circuit panel said they reversed the case, said that no, this is not really deciding who can say what. It's just determining what conduct and regulating what conduct doctors can do. Then a number of months later, they said, you know what, we've changed our mind.
Wait a minute, the same circuit?
Same circuit, just on their own, said, you know what?
You mean they reviewed their own case voluntarily?
They did.
How does that happen?
It doesn't happen all that often, but they did.
Okay.
And they said, we were wrong. It was a speech restriction, but it's still going to be a valid law.
Also, they did Justice Roberts' interpretation of the law.
Perhaps. But then it got even crazier. So last year, there was a case out of Arizona. A town named Gilbert had a sign ordinance that was challenged, and it was struck down. And so the 11th Circuit said, okay, in light of this case, we may need to revisit our second decision. So we're going to ask for new briefing. The attorneys and the parties need to come in and tell us how that Supreme Court case may have changed this case. So they issued a third opinion in December saying that, well, we're still going to reach the same conclusion. It's still a speech restriction, but we're still going to uphold it. But they did it in a way that hasn't really been resolved. And because of the three different opinions, the parties asked for just the entire 11th Circuit, all the judges, to re-review the case. And so now it's before the entire 11th Circuit.
Okay, so it was in front of a, what, three-judge panel before?
It was in front of a three-judge panel 3 times. Now,
the same three-judge panel?
The same 3 judges. The same breakdown each time, the same dissenting judge dissenting every time. By the third time, he just said in his dissent, I don't have anything new to say, just refer to my first and second dissents. So it's a mess. Hopefully we'll get something resolved this year.
Okay, now this is an interesting case from an emotional standpoint because with the latest gun control efforts done by executive fiat by President Obama, he's calling for a more proactive effort by the medical practitioners to ask about weapons in the home and that sort of thing, which of course
Sure.
Gun owners look at as very much, and probably credibly look at as kind of a slippery slope argument. Does it play into that fear?
It does, and that's essentially what led to the law being passed. But the problem is the passage of the law was based entirely on anecdotal evidence. There's only this one story that had any veracity to it of this happening at all, with it actually creating a problem. And so basically this was a solution in search of a problem. And the fears of being asked about gun ownership or possession, well, I mean, most people probably don't want their doctor asking them a question that may be entirely irrelevant to why they're there. Like, your knee hurts, well, do you own a gun? If that was asked of me, I don't think I would feel the need to answer that question, but at best that would be mildly annoying, and if it was truly annoying, most people can easily find a doctor. So to go with
well, that was true before Obamacare, but yes.
Well, be that as it may. But to take it to the step that the state of Florida did, to just effectively say doctors cannot ever talk about
so
this.
It's basically a restraint of speech.
It is
So
absolutely
prior restraint of speech.
It's a content-based restriction. It's singling out one particular message and one viewpoint.
And one profession.
In one profession, and saying you can't talk about that. And the First Amendment prohibits that.
Yeah, as it should. So, amicus on that?
PLF is also filing an amicus in that case. In support of the doctors, we're limiting it. The Supreme Court has never resolved the issue of professional speech. So professionals like doctors or attorneys, their conduct is certainly very heavily regulated by the states. But what they say is another matter versus conduct, and the Supreme Court has never said what kind of scrutiny laws that regulate what professionals can say should receive. And so PLF's brief will be making the argument that restrictions on professional speech should be subject to strict scrutiny just as any other content-based restrictions are.
So strict scrutiny meaning the hardest bar to...
Exactly, meaning the government has to have it not only a very good reason for passing the law that they've done, but it has to be very specifically drawn to not prohibit extra speech. So it has to be very narrowly tailored to solve a very specific problem.
Moving on to a third case. This one, we went from California to Florida. Now we're going back to the flyover country. Nashville is trying to limit Air BnB. How are they doing that, and what's the legal problem with that?
Well, Air BnB and VRBO, HomeAway, as sites like this become much more popular for tourists as opposed to going to hotels. Cities that are very dense and have tourist areas that people like to stay in but are also residential areas, they're becoming some problems and some externalities that weren't necessarily envisioned. So cities have tried to regulate this in a number of ways, some much more stringent than others. There are two particular things that Nashville has done that have proven problematic. One is they've completely prohibited any signs from being placed to advertise a home. So say you have your home, it's in a popular, trendy area where there are lots of restaurants, bars, museums, whatnot that people can walk to, and a young couple may want to stay in your home for a holiday weekend. Well, if you wanted to place a sign that said, "My home is available on Airbnb, view it there," or a sticker in your window so when the couple arrive at the home, they know it's the correct home and not your neighbor's and they're trying to get in the wrong home, well, this law would prevent that. But if you were selling your home or placing a sign, a normal for rent sign, that's perfectly allowed. So there's a couple
So in other words, you can't put a room for rent sign up, essentially.
You can put a room for rent sign up so
But
long as
only
it doesn't say room for rent on Airbnb.
Okay.
So it's solely targeting these short-term rental properties. And there's a couple that's challenging this law in Tennessee State Court right now because they, on one weekend for one festival, wanted to place a sign in their yard so people knew it was there. And then they also wanted to place a sticker so people knew they had the right house. Very harmless, innocuous things that no one could really object to, especially when you can have a for sale sign or a long-term for rent sign. It's not any more intrusive as those are. And so they've challenged that on First Amendment grounds. And more burdensome, the city of Nashville's also passed this requirement where if you don't live in this home, but you rent it out regularly on a short-term basis, they're only going to allow 3% of the properties in a certain area to do this. But if you still live in the home and rent out a room or just do it on a weekend basis, then conceivably everyone's home in a neighborhood could do this. So they've singled out the people who, for whatever reason, live in a different home and rent out this one, and they limit arbitrarily the number. I think it's something like 3% of the census tract. So if all of your neighbors have gotten these permits, whether they use them or not, and you just happen to be slow, then you can never rent out your home on Airbnb or a similar site.
Unless you live there.
Unless you live there, exactly.
Okay. So it's a commercial speech case, more or less.
It's a commercial speech, and it's an equal protection case because they've singled out one kind of property owner rather than another.
Mm-hmm. And the role of Pacific Legal in that case?
We'll also be supporting the homeowners in challenging the sign ban as well as the arbitrary limit to the number of properties in an amicus capacity.
And you anticipate, this is in what, circuit court or
It's
district
in
court?
Tennessee State District Court.
State District Court. So it's at the trial level at this point.
It's unusual for our involvement, but the issues are very interesting, and it's something that we're looking at more broadly, so it will be helpful, and it's something that this court has apparently never seen. So we're looking forward to being involved.
Okay. Moving along to the Sensational Smiles case. This is a case is I guess not going to be heard by the U.S. Supreme Court, unfortunately.
Unfortunately, Monday, the decisions from the first conference since Justice Scalia's death were issued, and Sensational Smiles was a case that involved a group of teeth whiteners in Connecticut. And teeth whitening is a fairly common, regular practice done in salons and malls, something that you can buy a kit at the pharmacy and take home and do on your own. Well, a group of dentists in Connecticut decided they didn't like this because they can charge very high prices for doing teeth whitening, and if they could prevent others from doing it on the cheap or then they would be able to have a monopoly on teeth whitening. So they had these teeth whitening companies shut down. So they sued.
How did they manage to shut them down? Did they get a law passed? Or
The
what?
Connecticut law defines the practice of dentistry very broadly, and so the dentists made the argument to the dental board that that definition included teeth whitening. The dental board agreed and sent cease and desist letters to the teeth whiteners saying you're practicing dentistry without a license.
So this is
You
a
must stop.
regulatory issue.
Exactly, and so they sued. They lost at the district court as well as in the Second Circuit and appealed to the Supreme Court, asking the Supreme Court to resolve the question of, is pure economic protectionism a legitimate government function? So in other words, can the government basically make a decision to regulate or ban something solely to protect another group or another player or another industry? And that's what the courts in this case had done, basically saying that that's perfectly legitimate. It's essentially politics, and if you don't like it, then go to your elected representatives to fix it.
Okay, so the dentists were not, or the dental regulators were not making an argument that only dentists have the skill and ability to do a teeth whitening properly?
No, and they really couldn't make that argument because that's kind of laughable.
It's a nonsense argument.
If you can go to a pharmacy and do this on yourself, the law actually would allow some of them. The practitioners use this UV light that you hold in your mouth, and so these companies could hand the light to the customer, and they sit in the chair and they hold and do it to themselves. But if the person actually held the light, then that violated the law. So to make any claim that this was looking to protect the public and look out for public health and safety is just absurd. It was purely there to make sure the dentists were the only ones who could charge for this, and it allows them to charge exorbitant rates.
So this is a good example of regulatory capture of a regulatory agency, or actually industry capture.
Exactly, and unfortunately there have been several cases in the last few years that have asked the Supreme Court to resolve this ultimate question of whether it's legitimate for government to do things just to benefit one group, and they've declined to take the cases and answer the question.
Well, that question has been answered by some other PLF cases, moving cases, right?
It has, and
In the correct way, I should say.
exactly, and more directly in a bigger capacity, our Ninth Circuit case, Merrifield v. Lockyer, the pest control case, the Ninth Circuit explicitly said that it is not legitimate for government to single out groups solely to protect others, but
So that's not a split in the circuits that the Supreme Court should address?
there is, and that's why this case was being urged to be accepted, and it's why PLF filed a brief asking the court to take it, because this case out of Connecticut was in the Second Circuit. There's a case from a few years back in the 10th Circuit out of Oklahoma that said the same thing. There are a few others that have taken the same stance as the Ninth Circuit and disagreeing.
Okay, so the Supreme Court requires, 4 votes in order to accept a case?
Correct.
And this vote was taken after the death of Scalia?
Yes.
So I'm guessing that the justices might be able to get 4 to take the case, but they're not going to bother if they know they don't have the 5th to make the case go in the direction they want it to go. Is that a fair assumption?
Well, who knows if there are even 4 willing to take a case.
But I mean, that's a good working hypothesis.
That's a good hypothesis, because if, say, Justice Thomas really wanted to take the case, but he was the only one, why would he go to the effort to convince 3 others if he knows
he can't get a 5th?
Right.
And I'm guessing that that's perhaps the reason they decided not to hear it, because with a 4-4 court and with the trial court or the appellate court decision in the wrong direction, even if they got a 4-4 vote, it would still be a loss for the people who are just trying to make an honest living.
Precisely.
Okay. The U.S. Army Corps of Engineers, this is a case that did get to the Supreme Court, a PLF case, a direct rep case, a PLF. U.S. Army Corps of Engineers versus Hawks. It's about mining peat. Tell us about the case and tell us how it got to the Supreme Court and what the facts and what the abuses are going on there.
So Hawks is essentially a family-run business based in Minnesota and North Dakota. They have a number of peat mining operations, and peat moss is used in a number of things. It can also be used, high quality peat can be used for golf greens. Well, they had some properties in Minnesota that were in wetlands areas where this moss grows, and they were very ample supplies. But since it grows in wetlands, the federal government regulates wetlands if they're connected to what are called navigable waters. And the state of Minnesota also regulates wetlands that are not in navigable waters. So Hawks Company knew that they needed to get the necessary permits to do this. So when they began the conversations to seek a permit with the federal government, it was made clear with the Corps of Engineers, it was basically made clear that this may not ever happen, and if it would, it was going to take years and a lot of money, and that it might make sense for Hawks Company to look elsewhere. But they had looked elsewhere, and this was the best property for their purposes, and they felt that this would allow the company to operate for quite a while and make a substantial amount of money.
Well, in the mining business, once you've depleted an existing mine, you have to find new mines to open in order to stay in business, correct?
By definition.
Yeah, and so they were just basically trying to keep the business operable by finding some new places to mine peat. And did the Minnesota permissions come through? State regulatory permission?
The briefs I've read don't really say, but it didn't seem that the state was creating any problems.
The state wasn't standing in the way.
It was pretty much all the United States Army Corps of Engineers.
And so what's the legal argument? That I mean, obviously peat grows in a wetland. I mean, that's by definition, it's a wetland plant or crop or product. So obviously it's in a wetland, and it's obviously being mined in North Dakota and elsewhere. Mm-hmm. What is the legal argument that the Army Corps of Engineers is using to say, but not here?
For them to have any jurisdiction, it would have to be a wetland in or near a navigable water. And in this case, the nearest navigable water was 120 miles away. So the Army Corps of Engineers had to make an argument that through fields, streams, gutters, any mixture that you could come up with to get water to move from this wetlands 120 miles would have to be all connected through something that's navigable to give them jurisdiction. Otherwise, it's all up to the state. And the Army Corps of Engineers decided that they could make this argument. And
seriously, they could make this argument, or said they could make the argument so that that they were just going to go ahead and do it anyway?
Well, the Hawks Company thinks that it's not a serious argument, and practically speaking, when there are fields and farms separating this wetland from the navigable water, it just seems practically impossible for them to be connected.
And the case will be argued, what, this month?
It will be argued at the end of the month, exactly.
Okay. That's the show.